Today is somewhat a historic day for the state of New York. I knew that we would not be able to get all the things in this bill, and some concessions were made. And it was very tough, very emotional, heartbreaking in some cases when it came to discussing our children in the Raise the Age bill. A bill that would raise the age of criminal responsibility from 16 and 17-year-olds to 18 was perhaps the most emotional, charged, and laborious process that this assembly had undertaken. So controversial to the point where those who opposed this bill were saying that our children were rapists and murderers. And those who supported and fought for this bill felt that we need to do more. It's not enough. Our kids are being incarcerated. Now, the reason why it's emotional and controversial is because currently, right now, in the state of New York, over 24 to 28,000 children, 16 and 17-year-olds, are being incarcerated on a yearly basis, are being prosecuted on a yearly basis, of which 50 to 60,000 are currently in the adult prison, as Assemblymember Lento mentioned earlier. Of that, the vast majority, are Black and Latinos. And the vast majority of the offenses are nonviolent offenses. Now, we ask, why has it taken New York State to be one of the only two states to actually pursue and passing this bill and raising the age? Why should this state continue to punish and have such harsh penal laws against children, especially on nonviolent crimes? Very similar to the Rockefeller drug law that was enacted in 1973, which was noted as the harshest penal law in the United States ever. It was supposedly a law that was targeting drug laws, major drug dealers. But however, most of the people who were incarcerated under this law were, again, Black and Latino men, disproportionately convicted of low-level, nonviolent offenses, and many of which had no criminal record. While Black and Latino people make up only 33% of New York State's population, they comprise nearly 90% of those incarcerated of drug felonies. This is one of the highest levels of racial disparity anywhere in the nation. I know because in the height of the 80s, my late brother, who served this country in the Army, became a substance abuse victim. And he too was incarcerated. No rehabilitation was offered to him, no mental health aid for this veteran who served in the Army. It was actually a habit that was picked up while he was serving the Army. My brother was left to die in prison. So in this case, we have been applying these same harsh penal laws to our children who are vulnerable and nonviolent felonies. It says that in the Supreme Court case, Graham versus Florida, in 2010, it was decided that juvenile offenders cannot be sentenced to life imprisonment without parole for non-homicide offenses. The court also previously had decided in the case of Roper versus Simmons, which had abolished the death penalty for juvenile offenders as unconstitutional, should apply also to sentences to life without the possibility of parole. And then in June 2012, in a related matter, Miller versus Alabama, the court ruled that mandatory sentences for life without parole for juvenile offenders, even in the cases of murder, was cruel and unusual punishment in violation of the 8th Amendment to the United States Constitution. Now why? Why was it deemed cruel? Well, the argument in those cases presented evidence that showed research in development psychology and neuroscience documents that juveniles are less mature, more vulnerable, and more changeable than adults. Juveniles have lesser capacity for mature judgment. Juveniles are more vulnerable to negative external influences. Juveniles' uniform identity makes it less likely that their events of fixed bad character, and more likely that they will reform. Juvenile psychosocial immaturity is consistent with emerging research regarding brain development. Sentencing the juvenile offenders in these cases to die in prison, like my brother, with no opportunity to demonstrate reform, is a disproportionate punishment. Raise the Age New York, on their website, also noted statistics shows that children, when they are incarcerated, they are easily victims of sexual assault, victims of solitary confinement, and victims of recidivism. Youth are 36 times to commit suicide, like our very own Khalif Browder, who was sentenced at the age of 17 at Rikers Island. And for a very long time, 16 and 17-year-olds who were not substance abusers, who were drug carriers, were sentenced to prison to die with no rehabilitation and no help. So the whole point of raising the age is not to treat these children as adults in the criminal system. We in the Assembly, when we started this whole bill, our whole goal was to start the offenses in the family court. And I want to thank all those who participated. I want to thank Speaker Carl Hastie for making this a priority and bringing this to the floor. I want to thank Assemblymember Joe Lento, who's carried this bill for 12 years, 12 years. And as he mentioned, finally saw the light of the day. I want to thank all the ambassadors who were involved in this process. Jeff Aubrey, who's been a voice for this for a very long time. For Ramos, who served as a law enforcement officer. Helene Weinstein, who had brought her judiciary expertise, who were at the table, fighting, negotiating. And I also want to thank my colleague, Latrice Walker, who I learned so much. She actually represents 16 and 17-year-olds who are going through this. And Diana Richardson, who actually have worked with rehabilitating juveniles who've gone through this process. And all of you who are here, so many voices who made this happen today, I want to thank you. But unfortunately, we weren't able to get the bill where we really wanted to, where to start at the family court. Why? Because our government is compromised. Our government is broken. We have a governor who unfortunately empowers the other party on the other side, who empowers a broken party that he should be part of. And instead, he's giving thanks to a party that was created that had nothing to do with the negotiation. Nothing. Everything started here. We are the people of the House. It was Carl Hastie, the Speaker, who led this bill to become a historic bill. And so I'm really disappointed in this whole political play. Credit should be due. Credit should be given where it's due. And it should be given to here, the people of the House. Meanwhile, all these other states, the vast majority of the states that have raised the age, start with the family court. Why can't we start at the family court? But we ended up with only misdemeanors and violations in the family court at the beginning. And non-violent felonies would start in the criminal youth part, where a district attorney would have a discretion whether to roll over this particular case, these cases, under extraordinary circumstances, unless extraordinary circumstances were found. And for what deemed to be violent felonies in many cases that are not really violent, like robbery and burglary, has to pass a three-part test. That includes significant physical injury, which again will have to be in the discretion of the judge and the DA. And unless there was an extraordinary circumstances found, these kids would remain in criminal court. Now, what does it mean, extraordinary circumstances? When most of these kids shared a life of extraordinary circumstances in itself, being socially and economically deprived, having drug lords coming into the community, poisoning our community, influencing little kids to sell drugs, raping our communities from economic equity, equality in our school systems, bringing chaos and deprivation. Isn't that extraordinary circumstances for a child's life already? But what it really means is we don't want it in the family court because we want to make sure that we employ these people in the criminal court. It's all about jobs. It's all about funding these facilities. And when we think about the 30 days that a child has to wait, again, where will they be? Where are they going to be housed? They're going to be housed in a facility that's used to harassing kids? Or should they be in a facility that has services provided for them while they wait for those 30 days? And after they serve their time, they have to wait 10 years to get their record sealed. So that means at the age of 17, that child is going to have to wait till the age of 27 to even see the light of pursuing an education or getting a job. Again, the Assembly fought for a better compromise. Joe and the team fought for a lesser number of years of sealing. We started at 3, then went to 5, but the governor insisted on 10-year sealing. I just wanted to, in closing, to talk about a young man by the name of Jim St. Germain, who lives in Assemblymember Diana Richardson's district in Crown Heights, who was raised in my district in Flatbush, who also happens to be a Haitian-American immigrant, who rallied with us in our press conference around Raise the Age. This young man was arrested at the age of 15, and he was just shy of 4 months of being 16. Made a big, big difference. And, I've heard my colleagues on the other side that said, well, there's a difference between 16 and 17 and 14 and 15. 4 months. As a result of him being 15, he went to family court, and he stayed in the judicial detention, juvenile detention center. And with that, he had an opportunity to afford the services of giving him a second chance in life. He actually decided to extend his stay in the juvenile detention center because he was crying for help. He wanted reform. So Jim St. Germain, after leaving the juvenile detention, he got his degree in criminal justice at John Jay, a bachelor's degree, and now he's working on his master's, and he will soon plan to go to law school. And I guess the whole point is, this is why we've been fighting to get a right raise the age. We feel that the youth offenders should really start at the family court. It makes all the difference. That's what the Assembly has been fighting for. That's what all the advocates have been fighting for. And to say that we're not thinking about the victims, this is not what raise the age is about. Of course, we're going to have legislations and laws and all the protection to serve all the victims. They come first. But we are talking about a disparity with the many of the 16 and 17-year-olds who go to jail for non-violent felonies. That's what we're talking about. We're not talking about the sexual assault cases. We're not talking about serious physical injury cases. We're not talking about display of guns and things of that nature. We're not talking about that. We are talking about the vast majority of 16 and 17-year-olds who are sentenced to prison in the adult criminal system for non-violent felonies. And we can make the comparison because we had a young white boy at Stanford University who actually committed a very violent felony. He raped a young student, and he got 6 months sentencing and 3-year probation. Meanwhile, the Central Five, the 5 young guys who got accused, Central Park 5, who got accused of raping someone, a felony that never even happened. And I remember because I went to school with one of those guys. When I was attending LaGuardia School of Performing Arts, I was in that classroom with Youssef. And at the age of 16 and 17, I didn't know what was going on. And imagine a 16 and 17-year-old is being approached by a district attorney, being forced to take a plea and admit to a crime they never committed. This is what we're dealing with. We're dealing with young people who are not mature to even make decisions for themselves. And so they need a break. They need services that's going to reform. So I just want to say that although the Raise the Age bill doesn't have all the things that we would like, I am grateful that at least the youth part of the criminal justice system, it will be presided before a family court judge. And I'm also happy that there will be a commission that's put in place so that we can continue looking at Raise the Age and tweak it. Today is definitely a historic day, and again, I just want to commend the Speaker, Carl Hasty, Assemblymember Joe Lento, and everyone else for pushing this bill and making it priority. And I just want to reiterate what Assemblymember Joe Lento said. He said that our children's lives are worth saving. And it was certainly worth saving this young man's life, Jim St. Germain, who is now working on behalf of a lot of young 16 and 17-year-olds who are incarcerated. And if my son was still living, I would have hoped he would have the chance and his life would be worth saving. So, Mr. Speaker, it is a great day. I support this bill. I support Raise the Age, and I will vote in the affirmative. Thank you.